Hello, I'm Sister Dale McDonald. Welcome to this presentation on public policy issues for Catholic school leaders. Before we begin, let us pause and ask God's blessing on our time together. In the name of the Father, and of the Son, and of the Holy Spirit, amen. Good and gracious God, we ask your blessing on us as we gather here. May all our words and actions be for your greater glory, now and forever. Amen. In the name of the Father, and of the Son, and of the Holy Spirit. Amen. This is the agenda that I will be presenting on today. What is public policy and why be involved? We'll look at some of the national education issues before the 117th climate and talk about the political climate in which these issues are being discussed and legislated. We'll look at recent challenges to Supreme Court decisions on private schools and religious liberty, how they're being affected by executive orders and congressional actions. And then we'll look at the issue of school choice at state and local issues. So what is public policy? Public policy affects all of us, whether we are conscious of it or not. My hope is that after this presentation, you will be more aware of the public policy issues and what you can do to become more engaged at the local level on education issues. Public policy is the underlying ideas and attitudes and beliefs that form the basis for action that will often result in regulations or laws that put these ideas into action. As you know, there are often competing viewpoints. Some are more consequential for our Catholic schools than others. Catholic schools, while independent of the public school system, are sometimes impacted by the decisions made by the local school boards in support of their public school interests. At the national level, Catholic school interests are monitored and represented by groups such as NCEA, the United States Conference of Catholic Bishops, the Council of American Private Education. But at the local level, there are not always organized groups to represent the schools. So when the school board meets to discuss budgets, is there someone there from your school to intervene when they are deciding to cut budget expenses by eliminating Catholic school busing, or to vaccinate only public school teachers? I mean, these are issues that we need someone on the ground at the local level to present a viewpoint while the issue is under discussion. Too often we react rather than be proactive about issues. And it's much harder to change a decision after it's made than it is to intervene in the process of making such decisions. For us, we have to remember that as a Catholic school, this applies to us as other nonprofit 504c3, the legal definition of organizations, that for us there are distinctions to be made between public policy formation and political activity, electioneering. We are allowed to engage in public policy, to share viewpoints, to try to influence outcome of decisions through lobbying, advocating, etc. We are not allowed to engage in electioneering. That's either directly or indirectly supporting or opposing a candidate for political office. So why be involved with public policy? As I said earlier, it's important that when the debate is being shaped and issues are defined, the viewpoint of Catholic education is part of that conversation, so that inadvertently or deliberately, we are not impacted by the consequences of the legislation in ways that would be detrimental to us. So we want to be there when the content of the legislation or the executive order or whatever they may call it at the local level are being developed, so that we are able to protect the interests of Catholic school families, the Catholic school personnel, and the church itself. NCEA has established public policy goals to be a strong, persuasive, and coherent voice for religious and private education, to exercise leadership in shaping public policies that impact education in Catholic and public schools. And I say public schools here because more than 20% of Catholic children are being educated in public schools, and they are the concern of the church, as well as only those in Catholic schools. So we do that at NCEA by engaging with others in the private school community to provide a coherent voice on behalf of private and religious education. And one of our ongoing policy goals was always to obtain federal education benefits for students and teachers in our schools that are comparable to what's provided to public school counterparts. All our families are tax-paying families, our teachers are taxpayers, and their taxpayer money should be used to benefit them, as well as an income in comparison with those in public schools that are benefiting from these tax dollars. Also, another important part of our political policy agenda is to support and affirm the rights of all parents to choose private and religious schools for their children. The Supreme Court a decade ago did support the right of parents to choose the education they desire, but did not say anything about supporting them. And we have been working to provide support for educational options for parents who are not able to afford them on their own. And the last part is, to attain and acknowledge support for the important roles private schools play in the United States. Private schools are 25% of those in the nation, and we educate almost 10% of the students. That's not an inconsequential piece of information to have when speaking with policymakers. So looking at the national agenda, we're looking at the political climate, and the climate has shifted in this past election. We now have a democratically controlled House and Senate and White House. And for the most part, we can say that public schools are their main agenda items. Over the years, the administrations have and private education have had differing relationships. As I said, the education committees in both houses are under Democratic control. The House has had Democratic leadership of the Education Committee for the past several sessions. And in dealing with legislation before the Congress, we've had to deal with some diminished and even some exclusion of private schools from some of the programs. In the first CARES Act, as the House restricted pandemic relief to students from low-income families only. And in other administrations going back, Democratic and Republican, anytime there was an emergency relief bill, whether it was hurricanes, wildfires, floods, et cetera, public and private school students and schools were treated equitably. That is not the case in the bill that eventually came out in CARES 1, where all public school students benefit from the program, and restriction on private school participation to low-income students has been something we have not been able to overcome. In the second relief package, the House specifically eliminated participation of private school students. That was, that bill never passed in the Senate, and so we escaped there. But then in the recovery bill that came following that in December, we had the EAMS, the Emergency Aid to Non-Public Schools, which did provide specific funding for private schools. In the bill that supplemented that, just recently passed, private school participation was again limited to low-income students. So there still persists this notion that our schools are wealthy and exclusive, And part of our policy agenda is to do much more to present the reality of private schools as serving all students with a preferential option for those who are low income and in vulnerable situations. And we need to try to change that narrative, which is starting to creep in and underlie some of the policy decisions. The administration itself has not said much other than its first priority is to get the schools open, the public schools open. The president did campaign on childcare and preschool, making it affordable and accessible to all, reopening schools, as I said, Title I, and then a lot of higher education bills. Most of what is proposed on the campaign trail has not been put into any kind of concrete action, but we will be monitoring that to make sure that private and religious schools are included. Secretary of Education, Miguel Cardona, has come from a public school background, has spoken about equity issues, and we're hoping that that will apply to the treatment of private schools. We'll be working on building a relationship with the Secretary of Education. Over the past number of years, as we've dealt with different administrations, we have had differing relationships, from very encouraging to indifferent to even at times hostility. So we will be working to forge a positive relationship with the private school community and the Department of Education going forward. And the big issue in public policy that we always look at is the federal aid to education. The Elementary and Secondary Education Act of 1965 did provide the first go-round of aid to students who were educationally disadvantaged. And over the years, that shifted away from aid to students to aid to schools. But under the construct of the program as it is, will be explained on the next slide, private school students do not qualify for a whole school aid. The individual student is and his or her teachers are aided, but not the school in general, the way the policy perspective has changed with regard to federal programs. So participation of students in private schools and their teachers is guided by two principles: the child benefit theory, where services are provided to students and teachers, but no financial aid to the school. The services must address the needs of private school students and their teachers, so the independence of the school is respected, and the fact that we may be operating on different curriculum and in different sets of standard testing and so on, so that the aid provided must meet the needs of the private school student and school. And then services for private school students must be equitable to those of their public school counterparts. And this is something that we have been focused on since the beginning and have not always seen very equitable results. And then the other is the public trusteeship of the money, that our schools do not get the money to spend. They get goods and services that they request the local public school district officials to spend their money, the money on behalf of their requests. And then they will only serve secular, neutral, and non-ideological positions. So what is equitable services? Well, generally speaking, the Department of Education tells us that service would be equitable when all students in public and private schools are provided equal opportunities for participation in the programs, and that those programs will meet the needs of the private school students and teachers and evaluate them in the same time frame and the same time manner. So it's not the public school comes first and the private schools come second. That the money should be used to provide approximately the same amount of services to students and all other educational personnel with the same needs. So it's basically treating private school students the way public school students similarly situated are with these dollars, and that there should be an equal amount of funds to serve public and private school students and educational personnel. In the last authorization of this bill, not only are teachers, but administrators, guidance counselors, and so on included in those who can be served with these dollars. Our biggest policy initiatives going forward now and probably in the next couple of months are the COVID-19 relief aid programs. They've been billed as relief aid programs, and we in the private school community are insisting on that and trying to be treated as we have been in past relief packages. Unfortunately, we have not had a great deal of success with that. The Governor's Emergency Relief Fund in the first CARES Act passed last spring has money earmarked for services for private school students and teachers, and if their school district is using money for that. The big package is the ESSER fund, the elementary and secondary relief that had $13.2 billion in that program. While we were expecting to participate as we had in other relief programs, there was a concerted campaign on behalf of the public school interests to limit our participation to Title I, as if it were a Title I program where only low income at-risk students are served. That went all the way through the court system in district courts before the Department of Education decided not to pursue it further and reverted it to being administered as Title I. So a great deal of funding that would have been equitably shared with us was not. So and we had done all kinds of, we meaning those representing the private school interests in the nation's capital, did work to try to get a better outcome, but were rebuffed. So the second CARES Act has two parts of the program: an EANS program, emergency assistance to non-public schools. And that allocated $2.75 billion for private schools, which was taking us out of then the ESSER 2 and the GEAR 2 and out of the squabbling over what portion of the money and who gets included. There's another bill now, hopefully by the time this is viewed by you, with the American Rescue Plan, which contains a second EANS program. But again, with some of this new takeover of the Democratic leadership in the Senate, we saw some restrictions in the program, particularly focusing again on low-income students only. And so we're looking to get a better interpretation of that. Schools have, and in both in the EANS package, if you were applying for that program, you could not apply for another payroll protection program. Many of our schools have participated in that program where you get a low-cost loan and it will cover things that the relief packages don't, like salaries and operating costs. But often those loans have been forgiven, which has been a huge help for sustaining many of our schools. Those PPP loans cover different things from what is allowable under the CARES programs and the EANS program, but and that are exclusive of each other. But unfortunately, the Congress has decided that you could only get one, not both, going forward. And then FEMA, late in the game, the president did declare COVID. The past president did declare COVID and a national emergency. And so applying that designation to COVID, schools now be reimbursed for protective measures. And so all of the PPP equipment and masks and all of that can be reimbursed if you've got receipts, can be reimbursed by FEMA. And then the FCC was able to, has been awarded the Homework Gap program, which will have little over $7 billion to help schools provide technology, hardware, software, connectivity devices to students whose families cannot afford. Many studies have shown that students from low income and rural areas have not had the same access to remote learning that their peers have, and have not been able to keep up. So with the homework gap, there will be a lot more funding available for schools to apply for with technology aid and connectivity aid for their students. The COVID relief package does have prescribed lists of things that you can get, so that the important thing is to look at what are the needs of your schools, your students, both for sanitization and sanitizing and for a safe physical environment, and then what is needed to make up for learning loss for individual students, for whole classes, for dealing with not only the homework gap, which we saw will be taken care of by FCC, but also, how do we make up for learning loss and for the emotional, social impacts of this COVID and the trauma that families and students have faced. And so all of those are things that schools need to be thinking of now. There is, a short time frame in which to apply for this money and get it committed to you, but you have until 2023, September of 2023, to actually spend that money. How have the districts or the state spend it for you? And so it's important that we begin to think creatively. How will we use the next 2 years to make up for the damages that COVID costs, both physically, emotionally, mentally, and in terms of learning? And so it's important that you follow a lot of the guidance that's being issued. There are certainly lots of information on the NCEA website about dealing with this great opportunity that's before all of our schools. Another issue that we're getting some concerns brought to our attention from people in the field deals with the whole notion of religious liberty and Catholic schools. The Religious Freedom Restoration Act protects religious freedom from federal interference. We know that the Constitution says that, Congress shall make no law establishing a religion. And the other equally important piece is, or preventing the free exercise thereof. And so as questions arose about social issues that were not accepted by all faiths, Congress did in 1993 pass the Religious Freedom Restoration Act, usually referred to as RFRA. That is to protect religious institutions and religious people from having their right to practice burdened by some government law, order, etc. So the RFRA Act says that governments should not burden exercise without compelling justification. And this is where we're starting to see some pushback about burdening free exercise. The RFRA says that government interference is allowable if it's necessary for the furtherance of a compelling government interest that relates directly with core constitutional issues. That's the language. And that if the government has to do that, has to interfere, it must be done in the least restrictive way in which to further the government interest. And the core constitutional issues that we are coming to some areas of disagreement with government center around specifically two civil rights laws, the Title VII of the Civil Rights Act of 1964 and Title IX of the Education Amendments. Title VII deals with hiring discrimination with exemptions, And it does say in Title VII that a religious corporation, association, et cetera, is exempt from this discrimination piece with respect to the employment of individuals of a particular religion to perform work connected with the carrying out of the mission or its activities. And so built into Title VII is the permission to hire for mission, that we in the Catholic world and other faith-based may hire people who will uphold the mission of, in our case, the school, that will not act and speak out in opposition to what is the teaching of the church. Title IX deals with discrimination based on sex in education programs and schools that receive federal funds. Okay, so if our schools are following all the rules for the title programs and for these COVID relief programs, we are not recipient of federal funds. We are getting goods and services delivered by and paid for by the public school district or the state education agency, that we are not spending the money ourselves, but are requesting goods and services. So that Title IX, if you are following that, does not apply. If you were in a position to take a federal grant of money in some other program, you still would not have to follow the Title IX prescriptions and follow part of it that would be inconsistent with religious tenets. And as faith-based organizations, we are able to claim that exemption. And that is coming to the fore even more. Because what is happening is a change in attitude and understandings of protected class. All right, the protected class is a characteristic of persons which cannot be targeted as the civil rights statutes and regulations say. So we see here, and most of it we're very familiar with: race, religion, national origin, et cetera. Up until a few years ago, the term sex was understood to mean gender, whether you were born male or female. In the last number of years, conversation has shifted greatly around that, so that now we are having executive orders, we're having the Equal Employment Opportunity Commission, and local laws and interpretations saying that sex should include sexual orientation, gender identity, SOGI. And so we see on many applications, when they're asking you for sex, it says male, female, and other unspecified, et cetera. So that we're seeing now significant clashes between people looking to advance new anti-discrimination statutes against those trying to protect traditional religious freedoms. And this has become, a big issue in the public arena. Public policy has shifted to be more inclusive of sex, including, SOGI interpretations, which is in conflict to many, not just Catholic faith, but to many people of faith traditions. And so if SOGI becomes a protected class, which a bill before Congress is saying that it is, it will apply universally. Right now, under executive orders, there were orders under the Obama administration, particularly to interpret Title IX to allow students to declare their sexual orientation, gender identity as they chose. That was reversed during the Trump administration. And now, again, one of the first things Biden did when he took office was to promote a new, again, to revert back to the understanding of sex, meaning sexual orientation or gender identity. It's important to keep in mind that state governments cannot do any less than what federal law requires, but they can do more. And so in some states, the understanding of sex as sexual orientation, gender identity has been state law and is being challenged in some cases, but has not been overcome. The Supreme Court has in recent years upheld religious liberty principles that try to make a distinction between discrimination and sincerely held religious belief. And that is part of our big public policy agenda to influence the debates that allow for people of faith and institutions that are of faith to not have to hire, et cetera, against their religious tenets. The Hosanna Tabor decision of the court dealt with a Missouri Lutheran Synod Lutheran Church that did not rehire a woman because of her not adhering to faith. That was upheld by the Supreme Court. The Hobby Lobby and Masterpiece cake shops dealt with whether an individual's sincerely held religious belief is enough to not have them have to accept behaviors that are contrary to their teaching. Hobby Lobby was in response to the Affordable Care Act provision requiring provision of birth control, reproductive coverage, and Masterpiece Cake Shop was a cake baker designer who refused to craft a specific cake for a same-sex marriage. In Espinoza, this is the Montana school choice case in which faith-based schools were excluded from a program that had a scholarship granting organization, could not be used in a faith-based school. The Supreme Court said that the free exercise of religion says that you cannot be penalized simply because of your faith. And so the program has to be opened up. If you're having a school choice program, everyone should be eligible to participate and not exclude faith-based. And then in the Guadalupe case and the St. James versus Beale case, again, it was a question of not rehiring teachers. And the Supreme Court said it is not the position of the courts to decide what pieces of doctrine in the church are applicable or not, and to make interference in church governance. And so both cases, religious freedom, the right of the faith-based group to hire for mission and to require adherence to mission was upheld. And going forward, we know there are other cases out in the courts in which teachers being not rehired or actually fired for engaging in same-sex marriage are in the courts right now, and we're not sure whether it will make it to the Supreme Court. So for Catholic schools who are facing these issues, there are certain tenets that we believe, and that the first is that everyone is bound to respect the inherent dignity of each and every human person and to advocate for their well-being. And so we make distinctions between persons and behaviors. And that for a Catholic school, no one is entitled to attend a Catholic school. It is the free choice of parents who want that education. And if they do, Catholic schools are free to insist on the school's mission and purpose and to require adherence to that, or at least not outright opposition to it. And then Catholic schools are transparent in that human sexuality is addressed not only in light of the gospel and the catechism of the Catholic Church, but also in context of the faith community. And so parents of a school and in decisions on admitting children who have same-sex parents or who are transgender or any of these other issues. Individual decisions are made at the local level with the consultation and directive of the local bishop, so that where students to come into the schools, families have to know that despite the circumstances of the family or the student, the Catholic Church teaches what the Catholic Church believes and does not modify it because of the family or the person. And that we also, are very insistent that federal, state, and local matters should not impede on the mission of the faith-based institutions. And that certainly has been upheld to this point by the Supreme Court. So one of our big challenges, of course, is to articulate the position of the church. And we have here the marriage as from the canon as between a man and a woman. Homosexuality as referenced in the Catechism of the Catholic Church, that while rejecting the behavior does require that the persons be respected and not unjustly discriminated against. So, and then gender identity, gender dysphoria, in which the church does not accept that sex is something that one decides rather than the way in which God has created the person. And so the big issue now before Congress is the Equality Act, in which the administration's policy is to prevent discrimination based on Title VII, Title IX, and particularly as it applies to schools. Children should be able to learn without worrying about whether they will be denied access to the restroom, the locker room, or school sports. In our schools, we make our own rules, and Title VII and Title IX does not apply to us. For schools, particularly the high schools, how that will apply when you're in a public school league and you have transgender students playing on girls or boys teams or in the locker rooms, et cetera, and how you respond. They set up a tension that has to be worked out at the local level without compromising what the church teaches and the schools requires as part of its mission. And so the Conference of Catholic Bishops has gone on record as opposing the Equality Act because it sees it as an imposition by Congress of a novel and divisive viewpoint regarding gender, and that church maintains that gender is not something that one determines for oneself. And so these are things that you need to be aware of and that need to be part of conversations on religious liberty going forward. And for schools trying to assert their RFRA protections, the first and most important thing is to remember that the bishop is the final authority and to decide in a diocese on matters of faith and morals. And so if any of these questions arise at your school, the first call should be to the superintendent's office to alert the superintendent and the bishop on what the issue is at hand before you begin to take action. And the ways in which we maintain, that this is a religious perspective and commitment is that the school mission statement should articulate the distinctly religious purposes through the mission statement that talks about the school's religious beliefs and statement of faith, that this is a tenet of our faith and that this is how we expect the mission to be carried out and by whom. The code of conduct for both students and for faculty should establish parameters for acceptable behavior, again, grounded in the statement of faith and mission. And for employment and admissions, in laying out the prospectus for someone applying for a position, that the religious mission as part of that person's employment is spelled out as part of the application process, that they understand what it is that they are applying for, or that the family understands in its application to attend the school what its position, the school's position is regarding conduct, code of conduct, its mission. And then most importantly, that you must consistently apply all admissions and employment standards to every case. Once you start to make exceptions, you are setting yourself up for a lawsuit. So hopefully that gives a little bit of perspective on where we're going with religious freedom and protection of religious liberty. And then another huge policy issue for NCEA is parental choice in education. And when you're looking at parents and choosing schools, there are really three perspectives, philosophical approaches to school choice. And we like to refer to it as parental choice. We're giving parents the right to choose the school best for their student. And so this marketplace competition approach, which is, let them choose everything, the best will survive, the whole Darwinian concept of survival of the fittest. The libertarian approach is that in which no government interference in any kind of education, that education should not be a government project. And then there's a social justice perspective, which says that care for the most vulnerable among us, including education, is a social justice issue, and that the Catholic Church certainly supports that. And so we approach parental choice certainly from a social justice perspective, that children, particularly of the poor and vulnerable, should not be penalized with a poor education, a poorly constructed education, because the family cannot afford what others of middle and upper income could. So over the last number of years, we've had national proposals for projects that have not gained any traction. The Bush administration, George Bush 1 and 2, had some initial flirtations with choice, but never really moved. The Obama administration did not give any traction to any of the programs. And while the Trump administration and the Department of Ed Secretary DeVos worked very hard to put these issues forward, they were never able to bring them tax credits or Title I, where you could take your Title I money and get a better supplemental services than the public school district might, pertaining vouchers to pay tuition or various pilots projects. They never got off the ground. And part of that is because choice continues to be a partisan issue. Back in the late 70s, early 80s, it was definitely a bipartisan issue with Senators Moynihan and Packwood leading efforts, but it never really became a truly bipartisan issue. And once we got to the Reagan administration in the mid-80s, it became a Republican issue. And we have not been able to overcome that in any of our push to get any Democrats to be willing to step out and to support choice initiatives. So it doesn't look good. And even back in the first session of the Bush administration with the Republican House, Senate, and Congress, House, Senate, and presidency, they were not able to get any of these issues moved. And so the future for choice lies with the states. We know now 31 states and the District of Columbia have some kind of choice program in which parents, usually restricted to low income or families with students with disabilities, are able to get some support to exercise their right to choose a school for their students. And so we continue to work at the local levels. This chart, which you can go back and look at, looks at the various programs and whether they're tax credit programs, vouchers, special needs, personal tax credits or deductions, or education savings amounts, where instead of the money going to the public school the student would be in, the family can access that funding to make choices for their child's education. The principles of school choice that we think should be part of any public policy discussion on choice programs are that the Supreme Court established a precedent that families could choose, that pluralism and diversity are part of the American tradition. We see that in every area except K-12 education. Preschool and college have publicly funded programs, but not K-12. And that equity and justice require that a quality education should not be conditioned upon a parent's ability to pay. And that choice does not violate the establishment clause because the money goes to the parent and the parent makes the choice. And in designing choice programs at the state level, we have worked at the federal level with the DC Opportunity Scholarship Program, but generally at the states. The important thing is that in any choice program, the autonomy and independence of the private school to operate as a private and faith-based school should be respected, and that student identity and dignity need to be protected, that you're not identifying scholarship kids or voucher kids, but that all enter into the school community on an equal basis. And that the choice legislation should not limit or restrict, as I say, their ability to operate as faith-based, and should not permit government interference of requiring more than what's necessary for health and safety, or requiring intrusive accountability measures, that they may want some proof that students are learning by taking or submit a prescribed test, or and making public some of the standardized tests that are used and so on. These are also always negotiated on a case-by-case basis with each state, but parents need to be the primary pushers for this kind of legislation with their states. Legislators listen to their constituents more than any organized group. And so our time is coming to an end, but this is my contact information, and the NCA website and the Department of Education Office of Non-Public Education website where you can obtain more information. So if you have questions that arose from this presentation, I'll be happy to answer. My email is there. So I thank you all, and have a good day for the rest of today, and thank you very much.